Hello and welcome to another opportunity to meet the author. This is a short series we're doing as we celebrate the launch of Blackstone's Employment Law and Practice, which has recently been published by Oxford University Press. Today I'm joined by Bianca Balmelli, who's going to talk about some of the developments in the work that she has done in updating the text. Hi Bianca. I think the first topic you were going to talk about is some developments in the test for just and equitable extension, is that right?
Yes, Lydia, thank you. Now, this aspect is dealt with in chapter 3 of the book. Now, as practitioners will know, the test around just and equitable extension of time is much wider than when one considers reasonably practical extensions of time. Now, practitioners will also be aware of the Keeble principles, which have been developed and which practitioners and the courts use almost as a checklist when trying to run an argument for just and equitable extension of time. Now, the problem with this is that in 2021, the Court of Appeal in Adedeji specifically warned practitioners from doing this. The court said that the approach that should be taken by tribunals is assessing all the relevant facts to the question of just and equitable extension of time, and then deciding whether, taking those into account, as well as length of delay and reason for delay, the extension should be granted. Now, the court went on to note that if that list is then checked against the Keeble factors, that's fine. But the Keeble factors should not be used as the framework within which the decision is made. As such, practitioners should be well aware of this new approach, and especially when drafting closing submissions.
There's also been some interesting developments in discrimination law, and particularly around philosophical belief. Is that right?
Yes, this point is addressed in chapter 16 of the book. Now, although Section 4 of the Equality Act does contain as a protected characteristic religion or belief, there's been only very limited cases dealing with belief as a protected characteristic. In 2010, the EAT in Nicholson versus Granger gave guidance on what amounts to philosophical belief. An important development in this area came about in 2021 in the case of Forstater, which held that a lack of belief is also protected under the Equality Act, regardless of the Granger principles. The EAT in Forstater held that a lack of belief in gender identity was merely an absence of belief and might arise from having no view on the subject at all. That lack of belief was protected irrespective of whether the Granger criteria could be applied to it. The EAT found it difficult to see how the criteria could be applied to a complete absence of belief. This is an area of the law that will see much development in the coming years, and it'll be interesting to see how Granger will be developed further.
Well, thank you, Bianca, and thank you for joining us as we look at some of the developments that are recorded in Blackstone's Employment Law and Practice.